So, like you said, I worked for the County of Ventura in the assessor's office for almost 17 years. I appraised residential, single family, condo, 4 units and less. Then I moved into the commercial realm where I worked on shopping centers, industrial complexes, and commercial properties. Then I went into agricultural appraisal within Ventura County, and then started working on a lot of more multi-res properties. Then I started supervising in the residential section, and then I was moved over to the appeals section, where I was the assessor's representative in front of the appeals board for a couple of years. From there, I went ahead and switched over to the other side, and I started helping people fight with the assessor or defend or challenge the assessor on their assessments or change of ownership issues. And I've been doing that since 2016.
Well, that sounds like you have a wealth of knowledge and experience that you've taken in throughout your career, and now you're really sharing it to the general public. Um, so, one of the things that I get asked about a lot is the supplemental notice. How does that happen? How does that get created? And how does that affect new incoming property owners?
Okay. The supplemental notice is what you receive after you purchase a property. And it's the difference between the old assessed value and the new assessed value. A typical change of ownership is when somebody goes out and buys a house. And they'll receive the supplemental notice saying that, okay, we're accepting your sales price or not, and we're increasing your property tax base to what your purchase price was. In many cases, as an example, let's say somebody is paying taxes on a $300,000 assessment and they sell their home for $800,000. The new buyer paid $500,000 more than what the prior owner did. So they're going to get a supplemental assessment for $500,000 to cover the fiscal year that they purchased the property. Now, in most instances, the assessor will enroll the purchase price, and they will do that whenever it's a change of ownership that involves a property that's listed on the open market, and they have some evidence or no evidence that the sales price can be rebutted. But the sales price is not the do-all, end-all. In other words, if the assessor sees a sales price of $800,000 in a neighborhood that's full of $1.2 million homes, they have the right to enroll $1.2 million. And the onus falls on the the taxpayer to challenge that value.
Now, when the transfer of ownership occurs, what is the usual timeline that the new homeowner can expect these assessments to come in?
The assessor works almost a year behind, sometimes more. So anything that occurs in 2023, right now, this current calendar year, the assessor is supposed to enroll it by June 30th of 2024. So the value that you receive on your upcoming October bill, if you just bought a new home today, it's going to reflect the old owner's value. So you will receive a tax bill for the old owner's value. Then you'll get your supplemental bill sometime between now and June 30th of next year that will reflect an addition to the 2023 tax bill. So it could take up, so if you bought it in January 2023, you might not get your supplemental for a year and a half.
Yeah, I've seen that happen with some of the clients where they call and say, but I paid my taxes, but
Yeah.
that was actually the old tax value. And they're kind of a little bit surprised when they get the new value in.
Right.
But that's just the system that's in place.
And the supplemental assessment, there's a disclosure when you purchase your home that the realtor is supposed to provide to you and title is supposed to provide to you, discussing the supplemental. And in the purchase agreement, there's a little paragraph about it also saying this is not, something that your bank is going to pay for you, something that you had to come up with the funds on your own.
Yeah, and this is why it's important to have a good qualified realtor kind of explain the process to you, because you don't want to be surprised or surprise any new homeowner with hey, you might get this type of tax bill in the future. They have to be prepared, of course, when they purchase their property to allow that for their home investment, their home a price and what they're willing to have on a monthly basis for their payment, right? They have to allocate all those funds for that.
Yes. And just as a defense to the assessor's office, having been an assessor's employee, that is the most common phone call that their employees will receive. What is this supplemental notice? And then they receive the bill and they see a huge increase in the value, and they'll call the assessor and complain about it and say, what gives you the right to do this? And it's not a right, it's an obligation on the part of the assessor to go ahead and roll fair market value and issue those supplemental notices.
So in the past, I've seen some of the talks that we've had. We've talked about escaped assessments, mm-hmm. or notice of an escaped assessment. Can you tell us a little bit about that?
An escape notice is typically when the assessor, and part of their constitutional obligations are to discover changes of ownership and new construction, is when they discover that there was a change of ownership or there was new construction in a prior year and they didn't pick it up. So the escape is covering the years in between when they should have reassessed you and the current year.
So that's an important thing to note whenever you have a potential buyer and they're buying a property that has things that are not on public record. There is a possibility that the assessor may come back and go back and reassess it for those escaped taxes. Is that correct? Is that a possibility?
In those situations, if they do discover that there was, like, let's say, a building addition, 500-600 square feet, and you purchase it with that building addition. Let's take the scenario where they actually had it permitted. Mm-hmm. Then in a situation where it was permitted and the assessor failed to go ahead and roll that new construction, the obligation is for the assessor to bill the old owner for those interim years up until they sold the property. But if it was there permitted when they purchased the property, when the new owner acquired the property, then it's part of the purchase price. Right. So they can't assess it to the new owner other than within the value that's established as a base value. And usually that's going to be the purchase price. Now, if it's a piece of structure that is not permitted, then the assessor can go ahead and bill both of them. But again, it's a situation where many people, when they buy a property that has an illegal addition, they'll go ahead and contact building and safety and get it legalized. So there could be some discrepancies between the assessor and the new owner as to whether or not it was or was not included in the sales price. But typically it's an after the fact permit. And most often than not, the assessor doesn't pick up additional value for it because it is included in the sales price.
Right. So I hear you. So if you've purchased the property and it's got this addition, you as the buyer are paying that premium to have that addition in it. And so that's basically the justification for the value. And if the assessor comes back and says you have this escaped value, you can counter that by saying, I purchased it because it has this specific square footage. Right?
Yes. Yeah. Now, I've also had a couple cases. One specifically that comes to mind is a client called me and they were being reassessed for new construction, specifically a swimming pool that they didn't build. And it took me a little while to convince the assessor that they didn't build the pool. And what I explained to them was, I think you might have made a mistake and added a pool to the wrong parcel. Because if you look at the air photos, the next door neighbor has a new pool that they didn't have a couple of years ago. And one of the things that I told them was, there's not a mistake that you can possibly make that I haven't made myself working for the assessor. So I wanted them to take a good look at it and explain to them why I thought this was the case. And it turned out that was the case.
When a person dies, usually a person that's on title, can you explain the process as the person receiving the inheritance of how what you need to do with the steps as according to the county assessor's office?
Okay. Well, according to the Revenue and Taxation Code, you're required to inform the assessor within 150 days of the death of the property owner. And that's regardless of whether it's held as a tenant in common, sole and separate property, joint tenancy, or through a trust. When the owner of the property dies, they must be informed within 150 days. And this is another common escape assessment. If you don't report it and the assessor discovers it, they can issue back taxes for up to 8 years. If you do report it and the assessor doesn't act upon it, they can issue back taxes up to 4 years. So there's different statute of limitations based on whether you do or do not report it. And this is also a very common escape assessment issue where somebody dies owning property held in their trust, kids inherit the property, and they don't report it, and they leave it in their parents' trust for 3, 5, 8, 12 years. I've had some go back to 2005. And when they sell the property, still in the name of their parents' trust, that's when the assessor typically will discover it, and they'll issue 8 years worth of back taxes. And that can be a real problem because they send the bills to the last known address, often the parents' house. And you have 60 days to file an appeal on an escape assessment based on when the notice was issued. If you do not receive those notices within 60 days through a forwarding address or something, then you lose your statute of limitations. The other issue comes with Proposition 19 and the parent-child exclusion. People whose parents died prior to February 15th, 2021 still qualify for the old laws. But in the case of where they had died and didn't get reported and they got 8 years worth of back taxes, they have 6 months to file that paperwork. If they don't file that paperwork, that money's lost. Where now, under Prop 19, if they died after February 16th, 2021, then you have a situation where if they did not move into the property, they're going to be required to pay those taxes. So right now, you're only looking at a couple of years. But what happens in 6 years, 7 years, 8 years, you get all those back taxes. Those are non-recoverable versus the old parent-child exclusion that it could have been canceled. And you could have, I mean, if you think about it, let's say you have a $300,000 assessment and you sell the property for 1.2 million, but it might have been worth 600,000 when your parents died. You got $3,000, $4,000 worth of property tax bills for 8 years. It can add up.
Yeah, and that's really the situation, is that disclosing of to the assessor in a timely fashion, and how the assessor basically sends the notice to the last current address, which is also a problem because sometimes they've moved, they've turned those properties into maybe rental properties. And so that's why it's very important to send out those notices so that you get the proper communication.
Yes.
So I want to talk a little bit about the Prop 19 that we were discussing about earlier. What is the biggest misconception about Prop 19 that you see people talk about?
The reassessment.
Mm-hmm.
Prior to Prop 19, the parent's primary residence was excluded from reassessment completely if you filed the right paperwork. Whereas under Prop 19, the parent's primary residence will be reassessed and you'll get a new base value established as of the date of the parent's death. Then, once the assessor does a comparison between the parent's old base value and the new base value, they can temporarily reduce the value of the property by $1 million maximum. And that $1 million maximum depends on the difference between the new base value and the old base value. Whereas if there's like a $300,000 difference, you get a $300,000 reduction. But if there's a $1.5 million difference, you'll get a $1 million reduction off the valuation. So the biggest misconception is that you won't get reassessed, but you will be reassessed. The other requirement is that you must move into the house within 1 year. And this is a big problem right now because When parents die, if they don't hold the property in a trust, then you have a situation where you may have to go through probate. And in some cases, those probates take up to 2 years. And if a child does not move into the house because they're not allowed to legally, they will lose their homeowner's exemption and they'll lose the parent-child exclusion.
Now, a lot of times where they won't be able to move into the house is because there's a disagreement with the estate, and that's why it's taken to probate. And I know exactly what you're talking about, and that's what takes up the time. Yes, when there is a disagreement amongst the inheritors.
Mm-hmm. And sometimes even when they agree, it could still take over a year.
Yes, that is true. So with the Prop 19, if I were to sell and I'm over a specific age, am I automatically covered when I buy my other home under that? Or are there any special things that I need to do to qualify for that Prop 19?
So you're talking about the base value transfer for people over 55.
Right.
In that case, prior to Prop 19, you could transfer your base value to another property within the same county. But there were value limitations. Example, if you sold a house for $800,000, you could buy a new home within 1 year, but you couldn't spend more than 5% more than what you sold it for. Within 2 years, you would have a 10% valuation grace. If you purchased the new home the same day that you closed escrow on the home that you're selling, then the new home had to be equal or lesser value. The new standard for this is you can go ahead and sell a property and buy a property, and the value difference is really not an issue. Other than if you're buying a home for more, they will add the difference in the sales price of your original property and the sales price or purchase price of the new property. The difference gets added to your tax base that you transfer. Now, also under the old law, you could transfer from one county to another under the same rules, provided both counties were participating. And there are only about 9 counties that participated before. So under the new law, all counties are required to participate. The other difference is, whereas before you could transfer the base value exactly one time, now you can transfer the base value up to 3 times. And if you're a married couple, it's 3 times per person. So technically 6 times.
So once you sold your home, you've bought the new replacement property, and are we done? Is there anything that I need to do to inform?
You have to file an application with the county that you moved to. If it's the same county, then of course it's whatever county you were living in before. But for instance, I've got somebody who moved up to Sacramento County, and I filed all the paperwork for them with Sacramento. They were moving out of Los Angeles, and Los Angeles has a big backlog. So we filed the paperwork almost a year ago, and they still haven't gotten their reduction yet. And we contacted the county, Sacramento. They said, we're not getting any response out of LA. You need to contact them.
So really, if they filed their paperwork, it takes a year, 18 months. Are they going to make that retroactive, or does that penalize that homeowner once he purchases that property?
It will be retroactive. They will receive refunds off their tax bills with a small percentage fee also.
And another thing also with Prop 19 and income properties. Now, prior to Prop 19, you were able to take those same assessed values in an income property or an investment property and just basically roll it over to the heirs. Is that still the case?
It is not. And it was a situation where up to $1 million worth of other property is how they termed it. So if you did have like a small shopping center that had an assessment of about, say, $800,000, It's below the $1 million threshold, even though it might have been worth $5 million. They looked at the assessed value, and they would actually, if it was less than $1 million, then you could keep that old base value. If it was a married couple that had passed away, a mother and a father, you had up to $2 million worth of assessed value.
And that was the old system, right?
Yes.
And
Now that doesn't exist now.
under the new Prop 19 guidelines, you would be reassessed at whatever the current market value is.
Correct. And that is challengeable. In other words, the assessor may go high.
Yes, and how does that reassessment take place? Does the assessor automatically do it? Do you as an individual do it? How do we get that assessment information done?
Again, you're supposed to notify the assessor upon the death of the property owner.
Mm-hmm.
And once they're aware of the death, then they create what they call a reassessment event. Mm-hmm. And they go ahead and reassess the property at fair market value as time permits. Again, they're supposed to do it, before the following June 30th of the next calendar year. But sometimes the assessor falls behind, and that's when they would issue roll corrections or escape assessments. And that's what you can file your appeal on, is the notice of reassessment.
And the appeal would be based on the time frame of when that assessment happened. Is that?
Most counties require you file within 60 days of receiving the notice of reassessment, mm-hmm. or the notice of supplemental, or notice of escape assessment. Some counties like Los Angeles and San Diego allow you to file your appeal based on the bill date, but the majority of the counties are notice counties.
So notice counties means that they would send out a notice and you would have to respond.
Correct.
Within that specific time.
60 days.
And if it doesn't happen, they will automatically implement those changes. Is that correct? Correct.
Now, if you miss your deadline to file on your notice or on your supplemental, you have 4 years from the year that the base value was enrolled to file an appeal on that base value. But it becomes prospective only, so you won't receive any refunds for prior years. So let's say in the open filing period begins July 2nd. And that period ends November 30th in most counties, but there's 12 counties where that filing period ends on September 15th. Ventura County is one of those counties where filing period ends on September 15th. Santa Barbara County is another. I think Santa Clara also, but that's just 3 of the 12. But what happens is, if you miss your filing deadline on the supplemental bill or supplemental notice, you can go ahead and file after July 2nd through either September 15th or November 30th, and up to 4 years. So as an example, let's say you had a change of ownership in 2021, the assessor didn't accept your sales price, or there was no sales price in the case of a date of death, and you didn't file on your supplemental, and you didn't file for the 2022 roll year, you can still file on the 2023. But you will not receive refunds off your supplemental if there is a reduction, and you won't receive refunds on your 2022 tax bill.
So another thing that I have a question on, and this is really with property owners in a specific case where their property has been taken by eminent domain and they have a replacement property. Now they also need to apply, because I believe they also let you carry over your same tax base. Can you tell us a little bit about that?
Yeah, they'll refer to that as a Prop 3. And what happens with that is, with eminent domain property, government takes over your property because you're going to build a freeway, a common example, and you can transfer that base value to another property of like quality and value. So that's the same sort of thing as if you had a calamity situation where you were a victim of wildfire or a victim of earthquake, and you didn't want to live in the same location. You could buy a new home and transfer your base value to the new residence. But they have to take a look at what the old value was and what the new value is, fair market wise. and you can transfer it over if you do like for like on valuation issues.
Well, I know that there's some guests with us today, and I really want to know if anybody has any questions for Kent. He's very experienced, and if there's anybody out there, just go ahead and present yourself and let us know what your question is about. Okay, but if not, we'll just continue. So there was a property, I think, that you said that you owned in the city of Ventura. I think it was a condo, and that's one of the investments where you got started, I'm guessing, in investing. And tell us a little bit about how you got into real estate, I guess.
Well, I started real estate kind of young. I was 19 or 20 when I bought my first property. And I bought it to live there, but I bought it partnership also with a family member. And I was 1/3 owner. Then I started doing more investing. I also bought my own properties to live in. But I use this example as another appeal situation. The assessor is required to enroll a value based on the sales price or fair market value, depending on which one is fair market value. And that becomes your base value, and that will increase by a maximum 2% per year, as long as you own the property. And the example that I'm giving with that investment condo is what happens when the market declines. So let's say you paid $800,000 for a property, but 2 years later, it's only worth $600,000, as what we saw back in 2007, 8, 9. The assessor is obligated to reduce that value to market value. And it's considered temporary because your base value still works in the background. And the assessor is supposed to review it annually. And as the market changes, if it goes down, they're supposed to reduce that value some more. But as it goes up, they're required to increase that value up to market value until your factored base year value is reinstated. So your factored base year value will increase by maximum 2% per year. But if you go on to a decline in value status, there's no limit to the amount the assessor can increase it on a percentage basis, provided they do not go above your factored base year value. So if you're on a decline in value for 8, 10, 12 years, your base value has increased by 16 to 25% over that same period of time. So that's what that's about. And the example that I gave with the condo that I sold it in 2005 near the end, which was near the peak of the market back at that time, for about $450,000. And currently, that factored base year value, had the same people still owned it, would be up over $625,000. But those condos are still only selling for about $550,000. And at the very bottom of the market, toward around the middle of 2012, they were only selling for $160,000. When the market crashed back in 2007 and 8, the whole banking crisis that occurred, I saw some properties reduce their values by close to 75%. It was pretty outrageous.
So it's important to note is that you can go ahead and you have to let the assessor know. He's not going to tell you many times that your property has dropped in value, right?
It depends. I know that in Ventura County, we were rather proactive on this, and I was working in their office at the time. We actually reviewed, it was based on when the properties were purchased. And we reviewed all properties that were purchased in 2007, 6, 5, 4, 3. And we actually went back to 1989, 90, and 91 because that was the previous peak. And if you look at the factor values on those were falling under Prop 8 also, or decline in value also. Plus, we looked at all condominiums, regardless of when they were purchased. And it was amazing how far back we were going in and applying decline in values to people.
So I think it's important to note is that Ventura County went ahead and were proactive in making those adjustments. However,
Yes.
I know LA County did not provide that service.
LA County was proactive in some neighborhoods, but not all.
And so, if for whatever reason your assessor isn't providing those services, how do people do a decline evaluation?
Well, of course, they could contact me and I'd help them with that. But they can also contact the assessor. There's forms that you can file,
Mhm,
but they're not an appeal form.
mhm.
And if the assessor is inundated with these forms, roll calls may come and go. And the assessor can send out a letter saying, sorry, we didn't have time, but you still have the right to appeal.
Right,
And if you don't appeal, then you'll lose out on it.
right, and that's the important part is that you have to appeal within that time frame. Otherwise, it just you just lose that ability.
Yes.
So I know what you're talking about the decline in value. So basically, if you filed a decline in value, your property was you bought it at 400, it's down to 200. There's a $200,000 difference. But it's important to note is that if in 2 years that property is back at 400,000, you're going to have your regular assessment. Is that correct?
Well, if you bought it at 400 and then it goes back up to 400, then you'll
Yes.
still be getting a decline in value because you have to add all those 2% factorings involved too.
Okay.
So it actually have to go above that factored base value before
I see.
you get your factor base your value back in.
I get it. So it would be the original sale date, purchase price, plus the 2% per year on the value.
Right.
Okay, I get that. That's perfect. Um, Prop 19. This is the one that really throws a lot of the realtors into kind of a tailspin because uh, uh, the majority of the property owners now are baby boomers, and they're above 55. I mean,
Yeah.
it's throughout the entire nation. They're the majority property holders, and the one thing that gets asked a lot is it beneficial? Is it beneficial to sell one for the other? I mean, I think it all depends on their personal situation. But if you want to downgrade, if they want to go ahead and move closer to a family member, I think that makes it possible.
Mhm.
Have you seen an increase in people talking about selling their properties because of this Prop 19?
I haven't seen a huge increase in it,
Mhm.
but I have dealt with a lot of people that are doing it.
Okay.
They want to make sure they have all their I's dotted and T's crossed. They want to make sure they qualify. Um, One thing I also like to stress to people, and it's the main reason why, I mentioned that only 9 counties used to participate in this.
Mhm.
The thing that I'd like to stress is why a lot of counties did not participate. Remember, there's 58 counties in California,
Right.
and values differ from county to county, especially right along the coast and in the big cities. The example I like to give is if somebody is moving out of, say, Bel Air or Beverly Hills, and they're selling their home for 5 million, 8 million, $12 million,
Right.
and they're moving to someplace like Shasta County or Stanislaus County or someplace where values are not as high.
Right.
And they're selling their half-acre lot in Bel Air and buying a 10-acre parcel in Stanislaus. And they're selling their home for $8 million, and they buy their 10-acre parcel for $300,000 or $500,000, and it's vacant. They take with them what's called a construction credit, and they can build a new home for up to $7.5 million and still keep their old property tax base. So you get a new construction credit when you transfer your base value from one property to another if you're buying for less or if you're buying vacant land. So here's the other example. You sell your $8 million home in Bel Air and you buy a $2 million home in Stanislaus County. Well, that's a lot of home in Stanislaus. You have a $6 million construction credit where you can build an ADU or an addition or something else. And as long as you stay below a $6 million threshold, there's no reassessment. And you still have to do it within 2 years also.
So, and that's that would be in your example of the Bel Air property, that would be the sale price, right?
Yes.
Yes, not the assessed value. It's the assessed value, right? So
yeah, I've seen $8 million homes sell that have an assessed value of $300,000 and $500,000.
right. Yeah, they've owned that property for that many years, or that
Yes.
it's been in their family for that long. I hear you. So in those situations, they have the ability within the 2 years to have that construction credit.
Correct.
So if they wanted to go ahead and build a 50 bedroom house, they could probably go ahead and do it and not get taxed. It wouldn't make a lot of sense, but
yeah, but technically they could. But that's the example I use as an extreme.
Right, exactly. I hear you. And let's see what else here I have. So if they wanted, if somebody from an audience wanted to go ahead and contact you, how would they do that?
They can go to my website and they can go ahead and contact me through that. They can call me or email me. So I can put my information in the chat.
And I think it's also important is prior to a change of ownership, if you have questions, I mean, you're available, because once that change of ownership happens, then you're kind of out. So it's important to do things prior to really making any changes.
If you want to be on the safe side, yes.
Right, and I think that's why it's so important to contact someone to actually look over what your idea is prior to submitting documents, just to make sure that the T's are crossed and the dots are, the I's are dotted. So it aligns with what your plan is with that property.
Right, and we also have a question here about the 2%. Does it end, or does the 2% continue for life? And the answer is it just continues as long as you own the property.
Right, and when we're talking about the 2%, that is the increase in assessment per year.
Correct. It's based on the California CPI. In the California CPI, maximum 2% per year. There was 1 year since this was initiated through Prop 13 in 1978, where CPI was negative by 0.25%.
And in that instance, did that carry over to the assessment properties? Did they have a reduction?
To the assessment properties?
Right. Well, where they
yes, your base value actually went down that year.
Right, but that's in how many years have you seen that? I mean, it's not very likely.
One time,
yes. And even though inflation is high and the CPI is actually higher than the 2%, they are regulated, or it's law that they can only go up to the 2%.
Correct.
Right. So I think having a person like Kent as part of your team, a go-to, is very important, because as everybody's seen, the tax structure, not the tax structure, the assessment structure has changed drastically, I think, over the last 2 years, and there's still a lot of questions out there. So I really appreciate your time that you taken to talk about the Prop 19 and the assessment process. And if there's anything that anybody else wants to ask, now's the opportunity. He's a wealth of knowledge. But if for whatever reason you can't remember, and it comes up later, you can always contact him. His website is apntax.com.